here. So already we have already done. This is the eighth session, I think, and seventh session we have already done. So I'm the moderator here only. So this is the interactive session because we have required the all the participant suggestions and feedback on the regulations. So the ICSI IPA can recommend to the IBPI for the further changes or amendments. So I'm welcome to all the participants who are participating here. So we'll start without any delaying. I just start with the regulation. And this is the interactive session. I already told you. So please participate and give your suggestion, whatever is required for the further changes in the regulations and the act also. So just sharing with the regulation. So I have shared my screen. So is my screen is visible?
Yes, ma'am.
Yes.
Thank
Yes,
you.
madam.
Okay, sir. Okay, sir. So I will show you. This is very recent amended regulation, and this is the topic of today's session. The Insolvency and Bankruptcy Board of India insolvency resolution process for the personal guarantor to the corporate debtor regulations 2019. So there is already amendment was made in up to 19 of May 2025.
Madam,
So
your voice is not audible.
my voice is audible. I'm asking to other participants.
It's audible, ma'am.
Audible, sir. Please check your
Ma'am, it's
connection.
audible. It's
Very
very
low volume, ma'am.
very low volume.
I just checked.
Low volume,
Okay.
low
It's
volume. Yeah.
Okay,
It's
I'm
audible,
just
but low
checking.
volume.
It is audible.
Okay, I'm just checking, sir. Give me a moment. Okay, now is audible?
Now it's okay.
Okay, thank you so much. Okay. So I will continue with this. This is the amendment which is up to the 19th May 2025. The amendment was already done by the IBPI in this regulation. However, if there is some further suggestions, so we will suggest to the ICSI IPA for the further amendments of or any. So we'll discuss with the regulation. So first, chapter 1 is the preliminary part. So these regulation may be called the Insolvency and Bankruptcy Board of India. Insolvency regulation process for the personal guarantor to the corporate debtor regulation 2019. So basically 2019 in the 2019 first day of December 2019 this regulation was came into force. Sir, please mute your mic. I'm requesting to the participants, kindly mute your mic. Uh, and second part is the application. So these regulation where apply shall apply to the insolvency resolution process for the personal guarantor to the corporate debtor. So whoever is the personal guarantor to the corporate debtor, this regulation is apply on them. And now this is the third part is the definition part, because in mostly regulations we have seen the second regulation will be the definition part, but here we will see the third is the definitions part. So kindly mute your mic, sir. Some disturbance was coming from the participant side. So I'm requesting, please mute your mic. So this is the definition part basically. Now we'll start with the definition. Associate. So what is the definition of associate here? In relation to the creditor or a creditor or a resolution professional or a professionals engaged by the resolution professional, as the case may be, shall have the same meaning as assigned to it in relation to debtor in subsection 2 of section 79. So what is this section basically? I will also show you the sections also. We will discuss the sections, whatever the relevant part of the sections also. We will discuss here. So 79 is basically the here is also. So this is basically saying the 79 subsection 2 associate of the debtor means a person who belongs to a immediate family of the debtor. So the associate of a debtor means it is defined here, but associate word is defined here. So they have said that shall have the same meaning as assigned to it in relation to a debtor in subsection 2 of section 29. So subsection 2 of section 79 is this: the associate of a debtor means a person who belongs to the immediate family of the debtor, a person who is a relative of the debtor or the relatives of the spouse of the debtor. So spouse is also covered here. A person who is the partnership firm, no, partnership with the debtor, a person who is a spouse or relatives of any person with whom the debtor is a partnership. The wide definition is covered here. A person who is the employer of the debtor or employee of the debtor. So these all are will be considered as the associate basically. So a company, they have also mentioned the company where the debtor or a debtor along with his associates own more than 50%. If there is a company, then they have owned 50% or more of a share capital of the company, or control the appointment of the board of directors of the company. So for this purpose, subsection relative with means to any person means anyone who is related to any other. If here they have also defined ki who will be considered as the relative. So in the explanation they have given, they are the members of the Hindu undivided family, and one person is related to the other in such a manner as may be prescribed. So there is some rules which was already made by the central government for this. So basically they are all associates. So they have covered in the definition of the associate. So we have to check thoroughly whether they are associate or not. So now code. So what is code? Code is the IBC code 2016 year. Now the corporate debtor means a person from whom the guarantor has given a personal guarantee. So basically the corporate debtor is the person to whom the personal guarantor was given the personal guarantee. Now electronic means is the same. I think we have already discussed in some other regulations part also. So means an authorized and secured computer program which is capable of producing confirmation of sending communication to the participant entitled to receive such communication at the last electronic mail address provided by the participant and keeping records of such communication. So this is the electronic means. Now from forms means a form appended to these regulations. So form is the forms whatever appended to these regulations. Now participants means a person entitled to attend a meeting of the creditors and include a creditor, the guarantor, the RP, or and any other person authorized through the resolution by the creditors to attend such meeting. So they will be called as a participant of the meeting. Now, resolution process means the insolvency resolution process of a guarantor, and the resolution process commencement date means the date of admission of application under section 100. So when we will file the application and it will be admitted before the NCLT, then will be considered this will be the resolution process commencement date. Now, the resolution process cost shall means fee payable to the RP or expenses and expenses incurred on and by the RP for carrying out the resolution process, including the fee of the professionals engaged if any. So his fee and the professional whoever was engaged by them will also be considered in this cost. Now, finance raised for the resolution process and cost incurred in raising such finance and such other costs directly relatable to the resolution process to the extent approved or ratified by the creditor. So this will be considered as a resolution process cost. Now, section means the section of the code and word and expression used and not defined in this regulation, but defined in the code under the solvency and bankruptcy application to the for the insolvency resolution process of the corporate person for guarantor to the corporate debtor rules shall have the respective meaning assigned to them in the code and the said rules. So now, is there any suggestions for any changes required in the definition part of the personal guarantor?
Madam, only the
Yes.
change of page will come.
Yes, sir.
When the slab or minimum page will come.
Yes, sir. This is also required, sir.
This-
The
yeah.
minimum slab is always the requirement because sometimes already recommendation have been sent to the IBBI
Yeah.
to make the regulation or to prescribe some minimum amount of fee in this case.
That's
So
circulated. That's
so
circulated. What
yes,
draft
yes,
regulation?
yes. So you have any draft regulation in your mind for this purpose or something you want to
It was already
suggest?
circulated. It was already circulated.
It is already circulated.
Yeah.
Okay, so this will be the call of the IBBI whether uh, how they will treat and how they will consider this. But there should be a minimum fee provision should be here, sir. So, is there any other changes, if any, required? Please also suggest. So, no change is required in the definition part, basically. Now, eligibility of the resolution professional. So, what is the eligibility criteria for becoming the RP here? Because this is some different criteria which we have already read in some other regulation. But at that time, there are some more eligibility criteria for becoming the RP in the personal guarantor cases mentioned here. And insolvency professionals shall be eligible to be appointed as a RP for the resolution process if he, the IPE of which he is a partner or director, and all the partners and director of said IPE are independent of the guarantor. He is not subject to any ongoing disciplinary proceeding or restraint order of the board or of the IPA of which he is the professional member, and IPE of which he is the partner or the director or any other partner of such or other partner or director of such IPE does not represent any party in the resolution process. So in IPE, if we will see, they cannot become the personal guarantor if any partner or director will representing in any party of the in the resolution process. So for the purpose of this sub-regulation, a person shall be considered independent of the guarantor if he is not an associate of the guarantor of and he is not a related party of the corporate debtor. The expression third part here is deleted. Earlier this was also exist, but now it is deleted. And the expression related party shall have the meaning assigned to it in subsection 24 of section 5. So whatever the definition which is defined in section 5 subsection 24 for the related party, this should be considered at the time of discussion of this not a related party of the CD. So here the IP the an insolvency professional other than who has filed an application under section 94 or 95 on behalf of the guarantor or creditor as the case may be shall provide a written consent in form A to the adjudicating authority before his appointment as the RP in a resolution process. So I'm just asking if any participant have any idea. Suppose if the CIRP process is already going on in the and the RP is the RP appointed in the case of the CD, and the same CD in the same CD case there is also a personal guarantor. So can the same person can become the personal guarantor as well as the means RP of the personal guarantor, and can also become the RP of the corporate debtor in the same
Yes.
case.
Yes, madam.
Yes.
Earlier it was no.
Yeah, because in 2024, this was amendment.
Yeah.
So this was omitted because basically this notification was omitted, which provides earlier ki has not acted or is not acting as the IRP, RP or liquidated in respect of the corporate debtor. So this was deleted after 31st January 2024. So now the person can become the RP in case of the personal guarantor case also. So this is the major change after 2024. Now preservation of records. So the RP shall preserve a physical as well as an electronic copy of the records relating to the resolution process of the guarantor as per the record a retention schedule as may be communicated by the board in consultation with the IPA. So there is basically no criteria basically have been prescribed here. However, they have said as may be communicated by the board in consultation with the IPA. So is there any changes required in this, or is any idea ki how many years practically have required to preserve the physical or the electronic records in case of the personal guarantor cases?
As long as it is not amended,
Yes, sir.
no issue.
So this have required, is there any amendment is required in this, sir?
Ma'am, I think that the preservation of records in case of PG matter, because it's a personal matter, so not more than 1 year should be provided therein.
But ma'am, there is the 8 years is already provided for the corporate debtor cases.
Ma'am, 8 years for the corporate, but as far as RP record is concerned, that is for 3 years only.
3 years for the electronic records, ma'am. But
For
for the physical
CIRP
records,
process matter, for ma'am,
yeah,
CIRP process matter,
yes,
not
CIRP
of the
process.
CD, not of the CD, because CD can be,
Hmm.
prosecuted thereafter. So
Hmm.
8 years is standard.
Hmm.
But RP's record could be maintained for 3 years, not for 8 years. So here RP record in PG matters should not be more than 1 year.
Ma'am, 3 years for the electronic records, as per my understanding or knowledge. And I think 8 years for is required to be maintained by the RP for the physical
That is for
records.
the
Yeah,
CD. That is
that
for the
is for the
CD.
corporate
Yes,
data,
that,
ma'am.
yes, yes.
Not for the
Not for the
CIRP process
personal guarantor.
conducted, the record that
Okay.
maintained by the RP. That is for 3 year only.
Okay,
Exactly.
so here the preservation of record should be mentioned as 1 year. Minimum 1 year or maximum 1 year should be prescribed here, as maybe minimum 1 year should be prescribed
For a
here,
period of at least 1 year.
at least 1 year. Now, debt counseling, the debt counseling in relation to the resolution process may be provided to the guarantor by such person as may be recognized by the board or the central government as the case may be. So, whatever is decided by the board or the
So, ma'am,
CGS.
sorry,
Yes.
with regard to preservation of records, what have you decided now?
Sir, 1 year was suggested by the participants. So, what is your opinion?
Yeah, that's fine. I mean,
Okay. Okay.
Yeah.
Okay, sir. Now, registration of claim, submission and verification of claim here. A creditor shall submit its claim along with the proof to the RP in Form B on or before the last date mentioned in public notice issued under subsection 1 of section 102. The creditor shall bear the cost relating to the submission of claim, including the proof under these regulations, and the creditor may prove its claim on the basis of the records available in the information utility or any other documentary evidence which substantiates the existence of the claim. And RP may call for such other evidence or clarification as he deemed fit from the creditors for substantiating the whole or the part of its claim. The RP shall verify each claim as soon as it is received and prepare the list of the creditors under subsection 1 of section 104 within 30 days from the date of the public notice. And where the amount claimed by the creditor is not precise due to any reason, the RP shall make the best estimate of the amount of claim based on the information available with them. The RP shall modify the amount of claim admitted, including the estimates of the claim made under subregulation 6 as soon as may be practicable after he come across the additional information warranting such revision till the approval of the repayment plan by the creditors. And the claim determined in foreign currency shall be valued in Indian currency at the official exchange rate as on the resolution process commencement date. So this resolution process commencement date should be considered the date from which the personal guarantor insolvency was started, or from the date from which the CD CIRP process was started. So is there any change suggested as per this regulation? The submission and verification of claim, and there is some something is provided which is related to the value, which is as per the Indian currency at the official exchange rate as on the resolution process commencement date. So, yeah.
Ma'am,
Yes, sir.
I think we will have to look at that when up to which period, in within how many days the claim has to be submitted to RP. Because as far as I remember,
Hmm.
I think 2 days ago in the program we discussed that the period of public notice shall be extended. That RP should be given extra time. So accordingly, we may have to adjust the period of claim as well over here. Otherwise, the corporate debtors, sorry, the claimants will have very little time. They won't have enough time to submit their claim.
So, what is your suggestion, sir, here?
CARP
Because
may not CARP may not be linked here because this is personal
yes,
insolvency.
yes, sir.
What is currently available is currently what is stated is
Here,
resolution.
I think here we
Process
will have
Resolution.
to look at that. Yeah,
commencement
Yeah,
date.
within how many days the claimants can file their claim from public notice.
Sir, I'm asking this, the claim denominated in foreign currency. Suppose if we have required to give any value to any claim, so what will be the exchange rate should be considered at the time of doing the valuation. So this will be the written here as on the resolution process commencement date. So resolution process commencement date for the uh, for the personal
not for
guarantor or for the
no definitely for the personal guarantor only, no,
yes. So yeah.
because CD CARP is not a requirement to initiate PARP.
No,
Yes.
I
CD
was
CDs.
discussing if you go up, ma'am. I was
Yes.
discussing on the period of filing of claim.
Yes, sir.
It should be, I think, subsection 3 or subsection 4.
Sir, period of filing of claim is mentioned here in case of the personal guarantor, which is written here. The creditor shall submit its claim along with the proof in Form B on or before the last date mentioned in the public announcement. So, provision is already here. Some I will also show you something.
Subsection 5 clearly says it has to be within 30 days.
Yes,
Sub-regulation 5.
yes. But for the personal guarantor cases, there is, because the public announcement date is more than the 21 days is given here, na? The adjudicating authority shall issue the public notice within 7 days of passing of the order under Section 100, inviting claim from all the creditors within 21 days. So basically, it is defined here. The 21 days was given to the creditor to submit their inviting the claim from the creditors. Now, the notice, whatever this is written, what is required to be added in the notice, and will also see what is the time which is prescribed for preparation of the list of creditors, because this is also relevant. The RP shall prepare a list of the creditor on the basis of the information, whatever filed by the section 94 or 95 as the case may be, and claim received by the RP under section 102. So, the 102 basically is written here. 21 days is given, inviting the claim from all the creditors within 21 days. But submission, how much time for the submission? I don't think there is anything is prescribed. 1 minute, I'm also seeing this section.
30 days. 30 days is little.
So the 30 days will be considered as per confirmation of the participants.
So I think there is
So,
enough period.
yeah. So this is the
Making clear.
30 days from the date of public notice, subsection 5, if you can see.
Yeah.
subsection 5.
There itself, ma'am. The previous slide. Here it is, ma'am.
That is for the preparation of the list of creditors,
List
sir.
of the claim.
Claim submission is 21 days.
21
Yes.
days, okay.
Yes, 21 days. Basically,
Right,
it is
right.
written here. This is written here. Within 21 days of such issue. Now, the RP shall modify the amount of claim admitted, including the, so I'm just asking, this is a resolution process commencement date is written here. So we can, suggest that the resolution process commencement date of the personal guarantor. So they can write, so the clarification should be there.
Not required, because
Not
these
required.
regulations are applicable only in the case of PG.
Correct.
So
Exactly.
these particular regulations
This
are
is-
applicable only to PG. So I
Exactly.
So
don't
we have to
Okay.
assume that resolution process commencement date, meaning it is PGIRP date.
Okay.
Yes, yes.
Okay.
There is no CIRP here, ma'am.
Yeah.
Okay, got it. So for the purpose of this sub-regulation, official exchange rate means the reference rate published by the RBI or derived from such reference rate. Now, transfer of debt due to the creditors, where the creditor assign or transfer the debt to any person during the resolution process period, both parties shall provide the RP, the terms of such assignment or transfer, and the identity and the details of the assignee or the transferee. The RP shall notify each creditor and the adjudicating authority of any resultant change in the list of creditor within 2 days of such change. So, is there any change required in this regulation?
Within earlier, I think we had changed it in CARP case,
Yes, sir.
wherein I think within 2 days of change, we changed to, I think within 2 days of the information received by RP, something like that we made it.
Yes, so here.
Because the
Yes,
most
sir.
important thing is RP has to receive the information about the assignment.
Yes. So RP shall notify each creditor and adjudicating authority of any resultant change in the list of creditors within 2 days of such change as intimated to the RP.
also
Within 2 days, within 2 days of receipt of such
from the receipt of such intimation
intimation.
by the RP.
No, if we are suggesting change, maybe we can increase the period also because 2 days is too less. If
Yes,
it
sir.
is a Saturday, Sunday, it's another issue. Plus,
Mhm.
how do we inform to adjudicating authority? Is
So
it by
we
way
can
of a
say
memo?
2 days or 2 working days from the date of intimation to the RP.
Or maybe we can just make it 5 days or something so that we get enough period. 7
Even
days.
1 week,
So-
5 days will not
Yeah.
make much of a difference there. Because in any case, it's only an intimation to adjudicating authority, which may not.
Sir, I don't
Yeah,
think.
but how do we indicate? How do we give the information to adjudicating authority? Is it by way of a memo or an IA?
2 working days from the
I think
date from the
If
date
it
of.
is IA, then
Hmm.
all the more a problem, right?
Yes,
Within 2
Yes,
days we have to
yes,
do
yes,
everything.
yes,
So
ma'am. Yes,
make
ma'am.
it as 7 days so that it is convenient.
We'll write. We'll see that
Yeah,
they.
suggest. Of
Yeah,
course.
yeah,
We can
yeah.
only suggest.
I'm just writing here 2 7 working days, but still they should change this language. At
Working
least.
days, they may not agree
Working
because
yeah, the
IBC,
complete
entire
things
IBC, it only talks about days. They
Yeah.
never talk about working days. And
Yes.
working days again differ from, other than Saturday, Sunday or public holidays, it differs from state to state. So that will be an issue.
Okay, so will days from the date of receipt of intimation.
Receipt of information by the RP, yeah.
My question is, if the assignment is not proper and the RP has an objection to that assignment is not properly done and he's not satisfied, then this intimation he cannot act on. So I think there should be some insertion that the assignment should be satisfactory to the RP. Well, there are stamp duty issue, transfer of debt is not normally an assignment. There are stamp duty issues, there are other issues. So any intimation which is not correct, how will you deal with it?
There is no such provision. If whatever I think whatever the intimation for the change, if they have received or the RP have received, but they are not satisfied with this, they can report to the adjudicating authority with the IA also, as per my understanding or something.
Yeah, I think while
So,
filing the
yeah,
IA, we
yeah,
should say
yeah.
that though we have received, there is a
Yeah.
change. However, we are not satisfied on these particular things.
Yes.
So let the
So
adjudicating
this is-
authority decide then.
Decide, yes. Now, the list of creditors, basically, the list of creditors under subsection 1 of section 104 shall contain the name of the creditors, amount claimed, amount admitted, and security interest, if any, in respect of such claim. The RP shall make the list of creditor available for inspection by the person who submitted the claim with proof. Serve the copy of the list of creditors to the guarantor. Make available the list of creditor on the website if any of the guarantor. Present the list of creditor at the meeting of the creditor, and file a certified copy of the list of creditor with the adjudicating authority along with the repayment plan. So basically, is there any change have required in this regulation? No. So we'll go on and move on in regulation 10. Now, statement of affairs. The RP shall prepare a statement of affairs of the regulator for the purpose of clause B of sub-regulation 3 of section 107. The statement of affairs shall include the following information of the guarantor: assets and liabilities for the preceding 3 years and the current financial years, details of the excluded assets and excluded debt. So what is the excluded assets and excluded debt is mentioned in the rules also. So here I have also opened some rules. These are the excluded assets. For the purpose of subsection 14 of section 79, these are the excluded assets, basically. The income statement for the preceding 3 financial year and the current financial year. So these are the basically statement of affairs of the guarantor, which required to be prepared by the RP, and income tax returns filed by the guarantor, if any, for the preceding 3 financial year. Creditor wise amount due broken up into secured and unsecured debt for the preceding 3 financial years. Detail of debt owned by the guarantor to his associates for the preceding 3 financial year. Guarantee given in relation to any of his debt, and whether any of the guarantor is an associate of the guarantor, and details of the financial statement for the business owned by the guarantor or of the firm in which he is the partner, as the case may be, for the preceding 3 financial year, if applicable. So basically have required to make this statement by the RP. Now, the fourth chapter is for the meeting of the creditors and voting. So I think there is some change came in 2025. No, something is changed, but later on we'll discuss in chapter 5. So here is the meeting of the creditors and voting. So the creditor who is included in the list of creditors shall be entitled to participate in the meeting of the creditors. The voting shares of each creditor shall be in proportion to the debt owed to such creditor. The RP shall convene the first meeting of the creditor in accordance with subsection 1 of section 107, and shall convene the meeting by giving such notice. So we will also see what is provided as per section 107. Summoning of the meeting of the creditors. The RP shall issue a notice calling the meeting of the creditor at least 14 days before the date fixed for such meeting. So such a longer time is prescribed here for giving the notice to the creditor meeting. RP shall send the notice of the meeting to the list of creditors prepared as per section 104. The notice sent under subsection 1 shall state the address of the adjudicating authority to which the repayment plan and report of the RP on the repayment plan has been submitted, and shall be accompanied by the copy of repayment plan, copy of the statement of affairs of the debtor, copy of the said report of the RP, and form of the for proxy voting and proxy voting, including the electronic proxy voting right, shall take place in such manner as may be prescribed. So basically define here the 14 days notice have required to be given before calling the meeting. Now, they have also mentioned the RP shall convene the meeting as per accordance with this, and shall convene the meeting by giving such notice to other participant as decided by the creditor, which shall not less than 48 hours. So basically, for the creditors, the 14 days notice, and if there any other participants want to participate in the meeting, then they have required to give 48 hours notice to them also. RP shall convene the meeting of the creditor on the request by the creditors having 33% of the voting shares of the creditors. And the notice under this regulation shall be served on every participant at the address provided to the RP in accordance with regulation 12. Unless otherwise provided in the code, any decision of the creditor shall require the approval of more than 50% of the voting shares of the creditor who voted. So basically require the approval of more than 50% of the voting of shares of the creditor who voted. So is there any change suggested here? Yes.
But 14 days is too long time.
Yes, sir.
14 days is too long.
But sir, have required to submit these all things, na? Uh, because we will send the notice of notice along with the notice we have required to submit all these things. So I don't think this is the possibility for the RP to prepare all these things before 14 days, within 7 days or 5 days.
But in any case, that 14 days mandate is as per the section, no? It is, can we review that?
Yes, there is a possibility. A regulation is there where you can propose this matter to the creditors and they can reduce the notice period for future meetings. The first meeting notice period has
Yes.
to be 14 days.
Yes.
That's what I'm saying. So the first notice period is 14 days as per the section 107
Yes. Yes,
of
sir.
IBC,
Yes, sir.
which is not under review by us. Is it not?
Yes, because we are only reviewing the regulations here.
Regulations, exactly.
Yes, sir. So still this is here, but still I will note it because some changes was also suggested by the ICSI IPA to the parliament level also. Some days before. So still I have noted here. Now the content of the notice for the meeting. So the notice convening the meeting of the creditor shall inform the participant of the venue, time, date of the meeting and the option available to participants to attend the meeting either in person or through the video conferencing or through the proxy, and creditor to cast vote in person through a proxy by electronic means or by electronic proxy as the case may be. Notice of the meeting shall carry the agenda, which shall include the following: list of matters to be discussed, list of issues to be voted upon, relevant documents in relation to the matters to be discussed and issued to be voted upon. If an option to attend the meeting through the VC is made available to the participant, the notice of the meeting shall state the process and manner for attending the meeting, provide the login ID, details of the facility for generating the password for access to the meeting in a secured manner, and provide the contact details of the person who shall address the queries connected with the video conferencing. If an option to cast vote by electronic means is made available to the creditor, the notice of the meeting shall state the process and the manner of casting vote by such means, provide the login ID and details of the facility for generating the password for access to the electronic means for casting vote in secure manner, and provide the contact details of the person who shall address the queries connected with the electronic means. So this is defined here. Now, or the quorum. The meeting of the creditor shall be void if creditors representing at least 33%, same in the CIRP cases, of voting shares as present in person, by proxy or through the VC, provided that the creditors in the meeting may modify the percentage of voting shares required for the quorum in respect of any future meeting of the creditors. So this percentage of 33 can also be modified by the creditors. Where the meeting of creditors should not be held for want of quorum unless the creditor have previously decided otherwise, the meeting shall automatically stand adjourned to the same time, place, and the next day, and on that day, no quorum shall be required. Now, conduct of the meeting. So, the RP shall preside over the meeting of the creditors. At the commencement of the meeting, RP shall take a roll call when every participant, including those attending by proxy or through the VC, shall state for the record the following: his name, his capacity in which he is attending, the creditor he is representing, if applicable, and that he has received the agenda and all the relevant materials for the meeting. So after the roll call, the RP shall inform the participants of the names of all persons who are present for the meeting and confirm, if required, quorum is complete. Now, RP shall ensure that the required quorum is present throughout the meeting from the commencement of meeting till its conclusion. No person other than the participant and any other person whose presence is required by the RP shall be allowed access to the meeting without the permission of the RP. Now, the voting by the creditors. So, RP shall take a vote of the creditor present in the meeting on any item listed for the voting after discussion on the same. At the conclusion of the meeting, RP shall prepare the minutes of the meeting, including the names of creditor who voted for, against, or abstained from the voting on the item put for the vote in the meeting. RP shall circulate the minutes of the meeting by electronic means to all the participants of the meeting within 48 hours. So this is also same in the CIRP cases. From the conclusion of the meeting, and seek a vote on the item listed for the voting in the meeting from the creditor who were not present at the meeting or did not vote in the meeting by electronic means, where the voting shall be kept open for at least 24 hours from the circulation of the minutes as the clause A. At the end of the voting period, the RP shall record the decision arrived at on the time, along with the names of the creditors who voted for, against, or abstained from voting on the item after considering the voting at the meeting and through the electronic means. The RP shall circulate the copy of the records made under sub-regulation to all the participants within 24 hours of the conclusion of the voting. So,
Ma'am, here in these regulations, there is
Yes.
a slight dilemma in 3A. It is said to circulate the minutes of the meeting by electronic means to all the participants of the meeting within 48
Yes.
hours of the conclusion of the meeting, and
Yes.
seek a vote on the item listed for the voting in the meeting from the creditors who were not present in the meeting.
Where,
So,
ma'am, this is I am seeing, this is here mentioned that the 48 hours they have circulate the meeting and
that is
seek a,
correct.
yes. Now seek a vote on the item listed for the voting in the meeting from the creditors who were not present in the meeting and did not vote at the meeting by electronic means, where the voting shall be kept open. At least voting should be kept open for 24 hours from the circulation of the minutes as per clause A. So
मैम इसमें जैसे CIP प्रोसेस में क्या होता है, जो वोटिंग इंस्ट्रक्शंस हैं, only those who are present at the meeting are taken. But if the person is not present at the meeting, then how can you seek the instructions through electronic mode? Because they have chose not to participate in the meeting.
So you were saying ki who were not present in the meeting or did not vote.
Should be deleted. Should be deleted.
No, madam, it is not that.
No.
It is not that purposely
Yes.
किसी ने अटेंड नहीं किया, हो सकता है कुछ मजबूरी होगी नहीं अटेंड कर पाए.
Yes, but हमें राइट तो देना पड़ेगा ना
बट
उनको
इलेक्ट्रॉनिक वोटिंग का राइट तो सभी का
राइट तो
रहेगा,
देना पड़ेगा,
जो
वो
आया
तो
है,
देना
जो नहीं
पड़ेगा.
आया है.
यस, वो तो देना पड़ेगा.
CIRP
Ma'am,
process it is not so.
CIRP
It is not CIRP process. Yes, it is different, little different from here. During CIRP process, the person who has not attended the meeting didn't get the right to vote.
Yes. That is treated as abstain or no voting. And decision is taken on present and voting present and voting basis. So in one of the PG matter, there is a creditor is there, bank. They are not taking the decision even after giving 30 days time period, and every time they are asking for the extension. So how to deal with this matter? There should be a time limit for them. If they have submitted with this, in addition to that, if they are submitting their voting within the prescribed 15 days or 20 days, then thereafter their right to vote should be closed. Something need to be prescribed for these creditors as well. Otherwise, the process will keep on lengthy and time consuming. Every time RP need to file an extension application, and in some cases NCLT don't provide the extension. Then what happen in that cases? Because in these cases that there is no fault of the PG, there is a fault of the creditor who are not voting on the prescribed agenda for resolution plan within a prescribed time period.
But
So
ma'am,
15 days or 20
also,
days
ma'am,
should be,
ma'am,
timeline should be fixed for them.
yes,
Ma'am, may I?
yes, yes, sir, yes.
It is clearly written that there is
That-
an option has to be given
Gi-
that voting
is
can be
open only
kept
for
open for that, and it is
24
written
hours.
in 4
Yes,
at the end of the voting period.
yes.
So after that, after one day, it's over.
Yes.
Whether you vote or not vote, there is
Yes.
no question of not voting or abstaining or
yes,
anything.
yes.
It's
So,
clearly
The
mentioned.
wisdom of the
Hmm.
COC is supreme, na. If the banker says that they have don't authority and will take approval for next and will take time 15-20 days. So these are
Here
the
nothing,
practical
here,
difficulties. Sir,
here
these are the
nothing like,
practical difficulties.
here nothing like
So,
that is
so
written.
if
It is
if
clear,
the
here,
regulation itself says that their right to vote is closed, then we can
so it
give
is
the
saying now, it is
relevance.
saying the
Ma'am,
same,
ma'am,
it is saying the same thing. It is saying the same thing
I
that
think we should,
it has to be kept open for 24 hours, and
but
at the end of the voting period, that means after 24-hour voting right
sir,
ends.
but we should
There is no
mention
question
here,
of reopening or delaying or asking anything.
sir, with the one suggestion, I'm also agree here, ki the person who has not attended the meeting, so the
He's,
voting should not be open for them. The person who has not attended for the
Yes,
meeting,
ma'am.
so
Yes,
it may
that
be
should
the
also be
No,
there.
no, no.
That should also be there.
it may be it.
Ma'am, in CARP, if you go through, I think I suggest you to go to the CARP regulation 26 because we need to read that also in parallel to this.
Yes. So my screen is visible now.
Yes, ma'am.
Mm.
26, madam.
$25, I think.
Yeah, even 25 and 26, little confusion will be there if you read it. Voting through electronic means is 26.
Shall provide each
member of the committee, not the
The-
members who attended the meeting.
Yes, and 25 also will see here.
25, 3 if you read, little different.
The RP shall
Shall
take a
take
vote of the
members of the committee present in the meeting.
On any item listed for the vote.
For
So
voting.
that is
After
for
the
the
shall-
class of creditors, you can say that. For the class
No.
of creditors, the RP is required to take the voting instructions. But in case if there is
there is
a
no
COC,
there is no clarity. There is no clarity. There is no.
but
It
sir,
doesn't say.
no, sir, in practical, in CIP process, what we do is, whosoever is present at the meeting, we just take the vote only from them.
Correct.
And not from those persons who are not present.
Yes.
Ma'am, 5B can be, we can read 5B also. Well, 25,
5B.
5B. Yes.
25
5B. Yes.
5B ना sir.
हाँ, 25 का 5 का
Okay,
B.
25 का B.
हाँ, 25 का 5 का B.
Yes, yes.
ये थोड़ा सा नीचे करिएगा मैम तो आ जाएगा मैम, लिटिल अप, लिटिल अप, लिटिल अप. अभी इसी प्रीविजो के ऊपर है. यस, ये है 5B
C
सी.
का vote.
हाँ, यस, यस.
of the member who did not vote at the
Sir,
meeting
इसका
or the matter
A का भी
listed for
देखिए
the
ना, circulate
voting.
the minutes of the meeting by electing to all the members of the committee and the authorized representative, if any, within 48 hours, and
Yeah.
seek a vote of them. These are for the class of creditors, sir.
Ma'am, where it is written, this is for the only for the class of creditors.
नहीं, no, ma'am. If you go by
Practically, what is
A, if
happening is, for
you
example,
A, that is to all the members of the CUC and the AR. If there is a combination of the committee of creditors and the AR, then it is there.
which provision are you reading, madam?
Sir,
5A, sir. 5A.
circulate the minutes.
CARP 25(5)(a), right?
Yes,
Yes.
25(5)(a) is saying the RP shall circulate the minutes of the meeting by electronic means to all members of the committee and the AR, if any, within 48 hours. So this is only for the circulation, ma'am.
Circulation of the minutes,
This is
right?
yes, this is not for the voting. Now
Right.
This is saying
now I will
AR
read this.
if any.
Yes,
This
AR
is AR if any. If there is AR,
only then will
only
circulate
then.
to.
If not AR, then main.
not. So now I will read this B also. Seek a vote of the members who did not vote at the meeting on the matters listed for the voting by electronic voting system in accordance with regulation 26, where the voting shall be kept open from the circulation of the minutes for such a time as decided by the committee, which shall not be less than 24 hours and shall not exceed 7 days.
Yes, true. If the member present at the meeting, if he says that I am not voting at the physical meeting, I'll do by the electronic meeting, then it's fine. Because in some cases, in the CIP process, in some cases, say 5 COC members are there.
I will also read this. The RP shall provide each members of the committee the means to exercise its vote by either electronic means.
Yes, ma'am. Yes, that is correct.
So the RP should give in the voting rights to each members of the committee.
Correct. But who are present at the meeting?
But nowhere it is written here ki the whoever is present in the meeting. It is
Ma'am,
written
earlier in 25, Mr. Joshi Katu has pointed out this thing. Regulation 25.
Yes,
Madam, they are written present and voting. And if not present and voting, then he can exercise later on. And here it is, the period is longer, 7 days. And between 25A and B, there is written and. So both has to be read simultaneously, not either. It is after 25A, in the end, it is written and. So A and B both.
The question is simple. Whether if a member is not attending a COC meeting,
whether he attending or not, he
yeah,
has
can
the
he
right. He is given the option. Vote? Yes, he can vote in the extended period. It is an option being given to everybody. Those who could attend, could not attend for any reason whatsoever, that may be intentional.
But sir, in CIP process, practical, this is not doing. This,
Madam,
whatever.
This is the act in a whether they are doing practically intentional or what. There is an option.
Sir, there is no provision.
Given. If option is not there, they not exercise at the end of the extended period. That period will go. That
no, sir. In the class of creditors, you can say this. In the class of creditor, you say this.
Yes.
How we can compare with the how can we link the PG and the CIP main?
Yeah,
two different things.
The law is providing that they should be given voting right for 24 hours.
The law says that they should be given the right. If they would not exercise, then we are giving the option. If an extended period of option not exercise, that means over.
Regulation is giving, so we are reviewing regulation.
So yeah, exactly. So that is law.
So in my opinion, in my understanding, CARP, somebody is not attending CARP. We are not providing any electronic means for voting.
We are providing.
There is no provision. Is there any provision to provide?
No, but in case of personal guarantor,
let's answer this. In CARP, is there any provision to provide for electronic voting for somebody who has not attended the meeting? Is there any regulation? I mean, I'm seeking your
what does then what does this regulation 25
because this is
a vote of the members who did not vote at the meeting.
Yes.
Sir,
the
who did not vote at the
Vote,
meeting?
but he was
Ma'am,
present in the
electronic
meeting.
system in
But
Yes.
he was present in the meeting.
There,
However,
sir,
he was
there
not
are
voted in the meeting.
there are
Yeah.
occasions, you know,
Yeah.
sometimes what
There
happens,
are
bank will
difference of wording. In that, it clearly says that whether the member was present or not, the creditor was present or not. But in CIRP, it is clear that he did not vote, but he must have been present in the meeting. So there are
he
some
was.
differences.
Yes.
May or may not be present. The line is not added there. That is present
Yeah, I
and did
don't,
not vote. Not mentioned there.
because
May or
lawmakers
may
must
not
have,
be present.
yeah, must
They
have
are
changed that wording after considering something. So only thing what I think that we should suggest for changes is the
Yes.
time period is given, that it says that voting shall be kept open for at least 24 hours.
Yes.
So there should be a maximum time as well. Some creditors may say that you keep open for 72 hours.
So, like the 7 days is mentioned in the CIRP process. So, you want to suggest at least 24 hours or
And
4
Up to,
days or
and
yeah,
not
2
more
days
than 7 days. Like
or
that.
not more
yes.
than 7 days.
Yeah.
So are we agreeing on the fact that in CARP process there is no provision?
But I'm also not agree with this. The person who are not present in the meeting.
Yes.
So how can we give the voting rights?
There is no need, because they are
Yeah.
also creditors. In PGIRP also, we are talking about creditors like banks.
Yes.
In
So when,
CARP,
Yes.
CARP also it is banks.
this is
Yes.
only a
So,
suggestion. So we can
yes.
suggest them that it should be on the line of the CIRP
Sir,
corporate data process.
Sir, in these PG cases, it is not only the bank who's a creditor.
Exactly.
It can
That
be
is
any individual, anybody is a creditor here. And for some
exactly.
reason, if
Correct.
somebody is not able to attend, doesn't mean he does not get right to vote. I don't think that's a fair option. This is correct. What it is given is correct. Just that
But
now we have to only say that it has to be kept open for at least 24 hours is written here. We can say at least 24 hours and not more than 7 days. Something like that. Some upper cap has to be there.
To deny voting right. What purpose it will serve?
okay. I'm just noting down. Now we'll move on. Regulation number 16, voting by proxy. So, is my screen is visible?
Yes, ma'am.
Some changes. A creditor who is entitled to vote at the meeting of creditors shall be entitled to appoint as an individual who shall not be an associate of.
Ma'am, your voice is very low. Very low. It is not. We are not able to listen to you.
Is now I'm speaking. Is my voice is audible?
It is very low, Sucheta. It is audible but very low.
Oh, so now am I audible?
Better.
Better.
It is better, ma'am.
But the full volume is, I think.
Ma'am, it is perfect now.
Okay. So, voting by proxy, a creditor who is entitled to vote at a meeting of the creditor shall be entitled to appoint an individual who shall not be an associate of the guarantor as a proxy to attend and vote on its behalf for the purpose of sub-regulation 1. The creditor shall deliver Form C duly completed to the RP at least 24 hours prior to the meeting of the creditor, and the proxy may vote by electronic means on behalf of the creditor. Now, chapter 5. So, there are some change was made in 2025. First, I will read this. What is the content of the repayment plan? The repayment plan shall provide the following: the terms of the repayment plan and its implementation schedule, including the amount to be repaid and date of repayment to the creditors, and the source of the fund that will be used to pay the resolution process cost, and that such payment shall be made in priority over any creditors. A minimum budget for the duration of the repayment plan to cover the reasonable expenses of the guarantor and the member of his immediate family to the extent they are dependent on him, or provided that at least 10% of the realizable income of the guarantor shall be utilized for the repayment of the debts. Financing requirement for the implementation of the repayment plan: if the guarantor has any business, the manner in which it is proposed to be conducted during the course of repayment plan and role of the RP, the manner in which fund held for the purpose of repayment plan invested or otherwise dealt with pending repayment to the creditors, functions which are to be undertaken by the RP, including the supervision, implementation of the repayment plan, variation of the onerous terms of the contract or transaction involving the guarantor, details of excluded assets, excluded debts of the guarantor, and terms and conditions of the for the discharge of the guarantor. So these all information required to be included in the repayment plan. And the repayment plan may provide for the following: transfer or sale of all or part of the assets of the guarantor, along with the mode and manner of such sale, administration or disposal of any fund of the guarantor, satisfaction or modification of any security interest, reduction in the amount payable to the creditors, curing or waiving of any breach of the debt due from the guarantor, modification in the terms of the repayment of any debt due from the guarantor, part of the income of the guarantor to be used for the repayment of debt, and the manner of calculating the income of the guarantor, manner in which the fund held for the purpose of repayment to the creditors and not so repaid at the end of the repayment plan are to be dealt with, and such other matter as may be required by the creditor. So is there any change required for the repayment plan, the content of the repayment plan? So no change required here. And the meeting of the creditors, the RP shall place a repayment plan as mentioned under section 105 in a meeting of the creditor for its consideration, provided that where no repayment plan has been received within such period as is stipulated under section 106, the RP shall notify the same in the meeting of the creditors. Now this is newly inserted basically on 19th May 2025. So what is inserted here? Where no repayment plan has been prepared by the debtor under section 105 of the code, the RP shall file an application with the approval of the creditor before the adjudicating authority, intimating the non-submission of the repayment plan and seek appropriate direction. So we will also see what is provided as per section 105 also. So there should not be any confusion. So this is the repayment plan section. The debtor shall prepare in consultation with the RP a repayment plan containing a proposal to the creditor for restructuring or of his debt or affairs. The repayment plan may authorize or require the RP to carry on the debtor business or trade on his behalf or in his name, or realize the assets of the debtor, or administer or dispose of any fund of the debtor, The repayment plan shall include the following, namely the justification for preparation of such repayment plan and reason on the basis of which the creditor may agree upon the plan, the provision for repayment of fee to the RP, and such other matter as may be prescribed. So basically, if there is no repayment plan is prepared by the debtor as per already provided as per section 105 of the code, the RP shall file an application with the approval of the creditor before the adjudicating authority, intimating the non-submission of repayment plan and seek appropriate directions. This is a change which was recently made. Now, Regulation 18, purchase of assets by the certain persons. The following person shall not purchase or acquire any interest in the property of the guarantor directly or indirectly without the permission of the adjudicating authority. The RP.
Madam,
yes, sir.
Madam,
Yes.
in this 17B,
Yes, ma'am.
17B, now what is happening is, see, earlier, even though there was no repayment plan, there was an IA which was filed with the adjudicating authority informing that there is no repayment plan received. So
Yes.
adjudicating authority can give the orders. Now what's happening? They say shall file an application with the approval of creditors.
Yes,
Now,
with the
creditors
approval of
again
the
are taking their own time to approve the, to give consent to file the IA. So here also some time limit has to be there.
Okay, so you are suggesting that with the approval of the creditor within days, something have required to be mentioned here also.
Yes, because see, when we do not receive the repayment plan within 21 days, as
Yes,
per
ma'am.
105, 106 and whatever. So
Hmm.
after that, within how many days should we take the approval of creditors to file an application to the adjudicating authority stating
Yes,
that we did not receive the repayment plan?
Hmm.
Some time period has to be there.
Hmm.
And we have to go further. Suppose within that period the committee of creditor doesn't give the approval, then the RP should have the right to file it
That's
without
right.
the solicitor.
Correct, sir.
So that has to be clarified over there.
That's right. Both.
And even in the previous amendment which we made, ma'am, in 15, I think there we have given a period up to 7 days.
Yes.
Even in that, a choice should be given, choice of time should be given to the RP.
Hmm.
Within 20 up minimum for minimum period of 24 hours up to 7 days as per the discretion of RP.
Hmm.
Otherwise,
what if the repayment plan is vague? He says, okay, I will repay after such a long period and creditors are not there. So I think what will be the better proper scenario, that committee of creditors should give yes or no within a reasonable period of time.
yeah,
Or,
that is what we are saying, sir.
yeah,
That,
yeah.
but if the committee of creditors does not give within that period, then then RP is filing to the adjudicating authority.
Here should be mandatory for the committee of creditor to say yes or no. They accept or not accept. What are that? They should decide. The thing is that they should be deciding. It's Sunday, tomorrow, day after tomorrow. No. They should decide. They say yes or no, or they say,
So
okay,
that
seek the new
then
plan. What
it
is
will
it?
linger the entire process.
Correct, sir. What Ajay sir is telling is correct, because if we cannot wait if the, see, generally what happens, it is happening with all the creditors. They neither say yes, they neither say no.
So it has to be decisive. If
No,
in the
and
entire
suppose that within suppose that within in that 10 days or 2 weeks, whatever period we have fixed, if the creditor is not giving their consent or not taking any decision at all on that, then RP can file an application with AA, and creditors, the right is always open that they can challenge in the with the AA.
Correct.
That this the period of repayment is too long. So AA can take a proper decision.
Correct. At least RP will be relieved.
Sir, it is better to in this to remove the word approval of creditors. There is no repayment plan.
Yes.
So it is there is no need to go to anybody. You have to go to double A that there is no repayment plan.
Yes.
That is
What is the
even
need of a
better.
creditor's approval here?
This suggestion is even better.
Yes.
Why there should be any need to go to creditors?
Yes. Otherwise, they should prescribe the time. Otherwise, I will also make a slash here. Now, purchase of assets by certain person. The following person shall not purchase or acquire any interest in the property of the guarantor directly or indirectly without the permission of the adjudicating authority. The RP or any partner or director of the IPE of which the RP is a partner or director, any professional appointed by the RP for the resolution process, any creditor, any company where the guarantor or a creditor is the promoter or director, any associate of the guarantor, creditor, or the RP, the adjudicating authority may set aside the purchase or acquisition made contrary to the provision of regulation and may make such order as may deem fit. Now, filing with the adjudicating authority, the RP shall file the repayment plan as approved by the creditor along with the report mentioned in section 106 or 112 as the case may be with the adjudicating authority on or before the completion of 120 days from the resolution process commencement date. The RP shall provide the copies of the document filed with the adjudicating authority under subregulation 1 to the guarantor and the creditor within 3 days from the date of such filing. Now, breach of repayment plan by the guarantor. If in the opinion of the RP, the guarantor has failed in implementation of the repayment plan, the RP shall within 3 days of knowledge of such failure issue the notice.
Sorry,
yes,
in Regulation 19.
Yes, sir. Yes, sir.
The resolution professional shall file the repayment plan as approved by the creditors.
Yes, if
So
there is
earlier we have just seen that somebody was suggesting why it has to be approved by the creditors.
Okay.
So
No, sir.
Yes.
Sir,
But
that is in 17B where there is no repayment plan which is received. That's what we were talking. Where repayment plan is received.
Yeah, no repayment plan, no approval of the creditors.
No approval of creditors is required. That's what we are suggesting.
Correct.
Yeah.
Now, breach of repayment plan by the guarantor. If in the opinion of the RP, the guarantor has failed in implementation of the repayment plan, the RP shall within 3 days of knowledge of such failure issue the notice to the guarantor identifying the failure and requiring him within 15 days of the receipt of the notice to address such failure if it can be addressed or provide an explanation for the failure. If the guarantor within the period specified under subregulation 1 address the failure in implementation of the repayment plan or provide a satisfactory explanation for such failure, the RP shall report the failure to the creditors within 7 days of the date of the failure addressed or explanation provided for such failure. In cases not covered under subregulation 2, the RP may apply to the adjudicating authority under section 2 of section 116 for directions if he is of the opinion that the failure will affect the implementation of the repayment plan. Now, application for discharge of the order. The RP shall, for the purpose of the discharge order, file an application along with the copy of the notice and report under section 117 to the adjudicating authority under section 119. On consideration of the notice and report as per section 117, the AA may pass the discharge order. Now, non-cooperation by the guarantor. In the event of non-cooperation of the guarantor at any time during the resolution process period or during the implementation of the repayment plan, the RP shall prepare a statement to this effect and file the same with the adjudicating authority for the appropriate direction. So basically, these are the regulations and these are only the forms which are required to be submitted by the personal guarantor in case of personal insolvency process. And there are some rules also prescribed for the personal insolvency cases. So there is no change as recently I have seen. So there is no change in these regulations. So basically, these are the same still because some of the definition have been mentioned here, and excluded assets was also mentioned here, and application of the guarantor in which form have required to be made. So fees or the forms have been mentioned here. In which form have required to file the application by the guarantor, and in which form required to be filed the application by the creditor. So these things are mentioned here. So is there any further suggestions or something if required, so we can discuss? Because I will show you.
Ma'am, in certain cases, when the application is filed by the personal guarantor himself under Section 94.
Yes, sir. Yes.
You know, what we have seen is, even though there is a
Yes, sir. Your voice is breaking, sir. Hello.
Excuse me, may I?
Yes, sir.
Yeah. So actually in entire process, there is a timeline, fixed timeline. Act is enabling to make something happen. It's a commercial act. So creditors are major stakeholder in the entire process. There should be some kind of definite time limits on them that they have to act within this period. Yes or no, it is their decision. But they have to decide. They cannot keep the things, okay, IP has to go, he has to wait, if there is a timeline, there are restrictions on the IP, on everybody. So there should be some kind of definite timeline, guidelines for the COC.
Sir, definite timeline is already mentioned within
No,
120 days.
I'm talking on the
Yes.
creators. I'm talking on the creators. There was all the time they may postpone, they may issue, they may not. On creators also, because they are the major stakeholders.
Yes, sir.
Lots of things depend on creators. Committee of creators, some present, some not present, some vote, some not, some seek.
Yes, sir.
So there should be some kind of definiteness in that okay, within this period you also have to.
Yes.
If act has to be successful, the aim of the act has to be successful. There, every time you see in most of the cases, even the Supreme Court is disturbed. Sometimes they say, oh, they are supreme, they decide, we depend on their commercial wisdom. Sometimes say no, they're not, and they put blame on the IP. So IP is enabler. IP is helping them. They have put timeline, they have put lots of restrictions.
I was
on the
making
IP.
a point. Sorry, I got the line got cut.
Yes, sir.
The point is clear now. I hope you heard what I said.
Yes, sir. Yes.
You know, when the Section 94 application is filed by a personal guarantor, many a time they are not paying the money for the initial expenses, which is again IP has to fight for it, and they have to cover it.
Yes.
The NCLT in many occasions have decided against the creditors, the banks. They have to pay the fees.
Yes.
So there should be this non-cooperation by the guarantor under Regulation 22.
So because one of the participant is already suggested in the beginning that some fee criteria should be mentioned for the personal guarantor cases also. So appropriate fees can be given to the RP also. So
and there should be some when any creditor is moved the application to the NCLT or registered against the operational creditor, but they are getting only adjournment is there from the last 1.5 years. So there is a suggestion, there should be some provision that the application is time bound by the NCLT.
Which application, sir? The initial application.
Initial application against the operational creditor.
Is Section 94 or 95, whatever.
Yeah.
Hello.
Okay.
Hello.
Yes, sir. So one my suggestion is also there. Yes, sir. Yes, sir.
Ma'am, entire 94 and 95 section.
Yes.
Appointment of RP, and there is no prescribed fee provided by the
Yes.
IBM.
Noted, sir. Noted, sir. Noted. This is noted, sir. I'm again noting.
Madam, here in this regulation 15 where you have typed.
No, one, sir, just no minimum fee, no? Sir, one more suggestion I'm also inserted here. Because I don't know whether this required to be inserted in the section or whether in the regulation. Because some of the cases are going on in the DRT, some are going on in the NCLT. So there is some means can say uh, we can say ki, the two parallel proceeding was going on against the personal guarantor. So I just want to suggest insertion of the non-obstacle clause or any regulatory guidance, something notwithstanding anything contained in any other law for the time being in force.
Madam, there should be a timeline procedure. Not when the operational creditor is filed an application, initial application to the NCLT.
Sir, but the recovery proceeding is already going on against the personal guarantor in the DRT also.
There is only adjournment. There is no proceeding at any other court of law.
So you are saying that suppose if we have filed the application before the
Against the operational creditor.
Yes, sir.
Against the operational creditor.
No, I'm saying.
No, sir, ma'am was talking about
the personal jurisdiction, because sometimes the parallel proceeding was going on against the personal guarantor in the DRT and as well as in the NCLT also. So I'm saying there should be a non-obstacle clause should be there. Notwithstanding anything contained in any other law for the time being in force upon the commencement of the insolvency resolution process of the personal guarantor, under these regulations, any proceeding initiated under the SURFACI Act or the Recovery of Debt or Bankruptcy Act 1993 in respect of the same debt shall be kept in abeyance until the approval or rejection of the repayment plan under section 114 of the code. So if the repayment plan is already in the process and the NCLT proceeding is are already going on, so there should not be the parallel proceeding should be initiated against the personal guarantor in any other forum like the DRT. So this is only my suggestion here. Whether for this the IBBI can insert any clause in the section or they can make any regulatory guidance or something. So
once the AA approves the plan, application.
Yes.
Other proceedings automatically comes on a standstill.
So you are saying if we have filed the application before the NCLT against the personal guarantor, so the DRT, we can also initiate the DRT proceeding as per SURFACI or other acts also.
No, as soon as that application is approved by AA against this personal guarantor.
So the interim
proceeding going on in any other court or forum will automatically come to a standstill. It will not continue.
But sir, what ma'am is trying to say, there are confusions with regard to the jurisdiction of NCLT and DRT in personal guarantee matters. What happens is, many a time in section 95 cases, the interpretation of section 60 is bad at many a time.
Sir, this has been answered by NTO.
Exactly. This has been answered by NCLT or NCLAT also. It has, already answered
so
this.
There is no confusion on the
now there is no confusion, but even now there are applications being filed in DRT directly under section 95 IBC when the CARP process is not on of a CD.
Sir, if that is the case, then DRT has to be educated.
I think this is what This is what
Yeah.
Madam Sucheta was suggesting, I guess.
Yes. Madam, agar if the DRT, we have filed the proceeding in the DRT as per section 95, and after filing this, the CD CIRP process was started, and then we have filed the proceeding before the NCLT against the personal guarantor. So there should be some more clarity on this.
See what I'm telling
Yeah.
you.
No.
Yes.
Even under in DRT, like Joshi sir was telling that even in DRT they are filing under section 95 of IBC. But on section 95 of IBC, the jurisdiction is only NCLT.
Yes. Yes, ma'am. Yes, ma'am. Correct. You are correct. But as per SURFACE, they can file the application in the DRT. And as per the Recovery of Debt and Bankruptcy Act, they can file the application. So there are some
SURFACE will not come under section 95, madam.
Yes, sir. I'm agree with this. SURFACE is not coming as per section 95. But the parallel proceeding was there in the DRT as well as in the NCLT. Whether these proceedings are in a separate act with the separate act they have filed. However, there is the two proceeding for the same debt was going on. For the recovery of the same debt was going on.
For that, I think moratorium should be applicable here.
Ma'am, I request you to go to part 3, section 78 and 79 for clarity purpose.
Yes.
Why the confusion has been created earlier, even that the confusion exists even now among some professionals. I mean, as
this part shall apply to the matters relating to the fresh start, insolvency and bankruptcy of individuals and partnership firms, where the amount of default is less than 1,000 rupees.
Exactly. Now we come down.
Yes,
provided
that the CG may notification specify the minimum amount of default of higher amount, which shall not be less than 1 lakh rupees. Now the definition is here.
Yes, the adjudicating authority means debt recovery. Yes. So now this is in part 3. Part 3, insolvency process for individuals and partnership firms.
Yes.
And the definition says adjudicating authority is DRT.
Yes.
Whereas the NCLT acquires the jurisdiction by way of section 60.
Section 95 also, 94. I
Section 95 is the application section. The jurisdiction of NCLT in personal guarantee matters is given by section 60.
Yes, sir.
Whereas section 60 is where section 60 is in part
individuals.
In part 1.
Part 3.
Section 60 is in part 1, no? Part 2.
8 minutes.
Part 2, sorry. Section 60 is in part 1, which is for CARP. You understand the confusion?
Yes.
Section 60 is in part 2, which is basically for CARP process only.
Yes, sir, you are correctly, absolutely right. But in view of the precedents passed by the Honorable Supreme Court, even if
I don't have confusion. I'm saying why the confusion has been created among professionals.
Because due to
why people are going to DRT?
Why
people are going to DRT? Because as per the definition section 79 itself is saying adjudicating authority for personal insolvency DRT. Whereas NCLT acquires the jurisdiction by way of section 60.
Yes.
Section 60 has not been interpreted properly earlier.
Yes.
But Supreme Court and NCLT also has interpreted it very well, and now there is no confusion at least among professionals who are practicing in NCLT. There is no confusion.
But sir, इसमें भी confusion कुछ ऐसा नहीं है. इसमें जो recent judgment pass हुआ for the Supreme Court in PG matter, even if the company is not under the CIRP, that PG matters can be taken care of. But those matters should be rightly pointed out to the DRT, not before the NCLT. But now the people are filing the PG matter even if the CIP process is not against the CD before the NCLT.
Yes, ma'am. So
So this is only my suggestion that because some confusion still is among with the professionals. So is if there is the clarity, if they have insert this clause or something, so this will be the more clarity here there.
No, I
So
think
yes.
giving this suggestion is not a bad idea, because till date the clarification is only due to that Supreme Court order, and if this is incorporated later
Yes.
in the code or the regulation itself, then it
Yes.
will be clear.
Yes. Yes,
No,
sir.
but here also any proceeding initiated under SARFAESI Act 2002,
Yes.
that may not fetch the result. Because what I meant to say is, even under IBC, people are going to DRT. And as per Section 96 moratorium, as per Section 96 moratorium, once an application has been filed in NCLT under Section 95 or 94,
Yes.
everything will be kept in abeyance.
Yes, yes,
Yes. Yes.
yes.
So there is no question of suggesting,
Yes.
about SARFAESI Act.
I am of
Okay.
the view, sir.
Okay.
This is what my point. I mean, in case of any difference of opinion, let's debate.
I agree, sir. I agree.
Section 179 also make it clear.
But the
Section
suggestion
179
can be given for
Section-
adjudicating authority. To
Section
make it clear
179.
who is the adjudicating authority, because
Section-
Supreme Court only has given in a particular decision, not IBBI. In IBBI regulation, it should be clear.
So Section 179 make it clear. Section 179.
But sir, even based on Supreme Court decisions and NCLAT decisions, maybe IBB, I don't know whether IBB can come out with a notification or circular something,
It is
saying
already
that,
it is already
Yes,
there. It is already there.
Then it then
Section
that's
179. Kindly refer Section 179.
correct.
179.
white shirt or blue shirt with
Please mute your mic, participants. Please mute your mic because some voice is coming from your side.
वो दे दी
Yes,
तो
sir.
शिष्टी एक बार दे दो ना तेरा जो तुम
It
Yes.
is clearly yeah.
ऊपर से
Subject to the provision of Section 60, the adjudicating
Exactly.
authority in relation to the insolvency matter of individual and firm shall be the DRT, having the territorial jurisdiction over the. Please mute your mic, please, ma'am. Please mute your mic. Vinita, ma'am, I think you should mute your mic. Vinita, ma'am, please mute your mic. So this is written here, subject to the provision of Section 60, the adjudicating authority in relation to the insolvency matters of individual and firm shall be a DRT, having the territorial jurisdiction over the place where the individual debtor actually and voluntarily resides or carries on the business or personally. Please mute your mic.
I think you can mute. You can mute. You have the right.
Sir.
ने इसको बोलने में बोल रही रोटी टाइम नहीं बनाएंगे काम करके आएगी सुबह किसी नाश्ता बना डेली 20 रुपए दे उसको डेली 60 रुपए ले रही है 3 दिन से
I don't think I'm not able to
Tell
mute.
Anjali.
ICSI IPA, please mute the mic of Vinita Agarwal. Vinita ma'am, please mute your mic. Madam, there is so much of disturbance. Ma'am, I have muted, I think. So this is the adjudicating authority for individuals and partnership firm. Subject to the provision of Section 60, the adjudicating authority in relation to the insolvency matters of the individuals and firm shall be the DRT, having the territorial jurisdiction over the place where the individual debtor actually and voluntarily resides or carries on the business or personally work for gain and can entertain an application under this code regarding such person. The DRT shall notwithstanding anything contained in any other law for the time being imposed, have jurisdiction to entertain or dispose of any suit or proceeding by or against the individual debtor, any claim made by or against the individual debtor, any question of priorities or any other question, whether of law or facts arising out of or in relation to the insolvency and bankruptcy of the individual debtor or firm under this code, and notwithstanding anything contained in limitation act this or any other law for the time being imposed in computing the period of limitation specified by for any suit or application in the name and on behalf of the debtor for which an order of moratorium has been made under this part, the period during which such moratorium is in place shall be excluded. So,
ma'am, what is
for
from this section?
individual and partnership.
Exactly, individual.
Yeah,
Section 95 is applicable. Section 95 is applicable to DRT as well.
Yes.
But in relation to individuals,
if they are the personal guarantor, if they are the personal guarantor, yes. If they are the personal guarantor, sir.
Personal guarantor in relation to a corporate debtor.
Yes.
All individuals are personal
this
guarantors.
Provision is only in case of individual and firm, which is not yet notified.
Correct.
Sir, we are talking about individual personal guarantors here. No, my point is individual personal guarantors in relation to a corporate debtor will be NCLT. For example, there is no company involved, there is no CD involved, but there are guarantees given.
That is correct, sir, but nowhere it is
written
that.
Then in that case, it will be DRT.
Yeah, exactly. Over there, you are right.
But sir, so many judgments are also there. They provide in fact, if there is no proceeding is going on against the CD, it still have the right to go.
Even if even if there is no CARP against the CD, but if there is a CD, then PG should be in NCLT.
Yes.
Imagine if there is
no CD.
There is
correct, sir.
Yeah.
No company at all.
But it should
then DRT section is 95. Section is 95.
Yes.
Section is 95, but it should be written this.
Yeah, that is why I said the confusion.
Yes.
There are
that confusion.
Lot of confusion.
So are we saying if the CIRP is not going on, then in that case the PG of that CD, the proceeding against that PG will go to the NCLT.
Yes, sir.
If CD, if proceeding in.
Sorry, my understanding is
I'm just rephrasing it. If the CIRP of corporate debtor is not going on, and the PG.
Your voice is.
Sir, not able to listen you, sir. You are not audible.
Yeah, let's not confuse so much.
The matter against that PG.
Boliye, sir.
It's a clear. If PG is related to the CD, it is NCLT. If PG is related not to CD, individual, it's DRT.
Then
DRT. It's very simple.
Yes.
Agree with the Joshi.
Yes.
Agree with the Joshi. It's a crystal clear.
Yes.
Thank
you. Yes.
So CARP is initiated or Amit Sab, CARP is initiated or not? But if there is a CD, then NCLT.
Yes.
But it is not so as per this section 60. It is not so.
And that is why there is confusion.
Yeah, all this section are interlinked. We need to understand it very thoroughly.
Sir, all this, has been clarified by jurisprudence that if it is a PG to CD, then the jurisdiction is NCLT. Over.
Ma'am, currently my name is Jagdish Ahuja, ma'am.
Yeah.
And currently I am having a case where I am appointed as personal guarantor by NCLT Mumbai, and the corporate debtor is not undergoing CRP process.
Yes, sir.
Yeah, that's why. In fact, I have finished my case. That's why I'm so confidently telling. I just finished the case.
CRP is not required.
Absolutely
CRP is not required.
Yes.
the case need not go to DRT. Still, it can go to NCLT.
Go to NCLT.
Manish
So
Kumar
I
Jajodia.
have also read some of the judgments which provides.
Jajodia, I think Manish Kumar Jajodia Supreme Court has already, I mean, that was 2 years old, 3 years old.
Yes. So
Madam,
I'm
I have
saying
also handled one case in which CIRP is not going on.
yes,
And
sir.
I have handled as a RP to a PG case. And that case
Okay.
is closed.
And this is in NCLT, na, sir?
Yes,
Your
Sucheta, we
case,
can move
yes,
forward.
yes,
This
yes,
discussion
I
is
think it's
taking-
very clear,
yes,
very
yeah,
clear,
yeah.
ma'am. We can move forward, yeah, please.
Yes, yes.
Well,
So,
as the auditors for the banks and the RBI's procedures of standard operating procedures, the banks are made to approach the DRT at all cases. Even in large cases, banks do file DRT cases before going ahead with CIRP. Large cases of CIRP as well as PG, as a standard operating procedure, all large banks go to DRT first and then they file a CIRP petition. So my only thing is that we need to protect the position of the creditors where promoters misuse Section 94 and the creditor misuse Section 95 in DRT after having gone there. So what happens is that the present judgments at all levels say that whatever be the situation, after kickoff of Section 100, the moratorium is 120. Whatever be the position, I will not allow you 121 days. Even RP says, please extend this Section 100 application. NCLT is passing the order that I am extending you Section 100, but there will be no extension of moratorium. So I think what this draft is required, kindly reread it and see that nobody misuses it. In my one cases, which is quite a big case, one of the creditor is trying to misuse 95 DRT after 120 days, where plan is under consideration. So my request is let's reread this modification suggested and see that there is no misuse under 94 or 95. It's a wonderful suggestion, good draft, but let it be tweaked a little bit that during the proceedings of Section 100, no other parallel proceeding should go. I think this is not required to say up to 114 or anything. 94 to 95 to 100, the moratorium is available, used or misused, whatever it is. So I request that kindly look at this suggestion and reword it judiciously. People will accept it at all places.
Okay, sir. So, if you have any draft or something, you can also put in the chat box if you have something to suggest. So now, can we conclude with these all suggestions? Or
Madam, here just
yes.
regulation 15. I just wanted a slight
Regulation?
Regulation 15, the one you have typed over there.
1 minute.
The same one, yeah, which was
Regulation 15.
No, not the regulation itself. Where you have typed, where
Okay,
we are
typed.
typing
Okay.
the amendments. Yeah.
Okay. Yes, sir.
Just a little up.
Yeah.
Yeah.
Okay.
In this one, what I suggest, I am suggesting, regulation 15 kept open for at least 24 hours and not more than 7 days from the circulation of the minutes as may be decided by RP. So here I think we should give flexibility to RP. Otherwise, they will take it a mandatory provision that at least for 7 days it should be open.
Sir,
that may not be suggestible.
Yeah,
because
which
they
may
have
be
to
kept open for the maximum day, maximum for 7 days, which may be kept
That's all.
open, which may be kept
Yes,
open.
Which may be kept open. The wording we can.
And
as mutually decided also we can just.
And up to 7 days, not more than, instead of not more than 7 days.
Up to 7 days.
And up to 7 days from the circulation of minutes. although this is not giving very clear thing, this becomes a mandatory, 7 days becomes a mandatory provision. Anyway, we can leave it. There's no problem.
Okay. So now I'm requesting to the ICSI IPA. Now can we conclude on the session? ICSI IPA, are you there?
Okay, thank you, ma'am.
Okay. Thank you, Sucheta. Thank you, IPA, ICSI.
So much, ma'am. Thank you so much. I'm just calling to the ICSI IPA. They are not concluding actually. I think 10 minutes are remaining. So
should I call Anjali?
Yeah. Yes, ma'am.
Thank you, madam. Thank you, madam.
Thank you so
ma'am.
much, sir.
Thank you,
Thank you
sister.
for attending. Thank you, sir.
Thank you, ma'am. Thank you all the participants.
Yes. So we are calling you. So now the conclusion. Can we conclude now, na?
Yes, ma'am. Yes.
Yes. Okay.
Thank you very much, ma'am.
Thank you.
Thank you all
so
the
much.
participants.
Thank you. Thank you to all.
Thank you.
Thank you.
हो गया